Dear friends, Namaskar. In this video, dear friends, we will be discussing the law or the legal provisions pertaining to recovery proceedings, that is, the recovery of overpayment made to the government servants, public servants. As it happens in many cases that the government realizes that some overpayment was made to its employees, or the employer realizes that by way of wrong fixation of salary or pay scale, overpayment was made, sometimes wrongly increment was given, sometimes whatever reason, that is ta da, in whatever terms payment was made, but it was wrongly, by oversight etc., was paid to the government servant, and sometimes it goes on very long time and then government realizes what is to be done. So normally government starts recovering that overpayment from the government servants. Now in this regard, what is the legal position? So recently Supreme Court decided a very landmark case in the case of Rafiq Masi versus State of Punjab. Actually, that case has been decided along with several other, maybe a few hundred other cases together. And in that case, Supreme Court scanned earlier judgments on the issue and laid down certain principles to settle this issue time and again arising. Broadly speaking, this judgment has laid down four principles which should be followed while effecting the recovery by the government. So, first such principle is that although overpayment is made but recovery is not possible, it should not be done in case it is against the government servant who is working on group C or group D. So, this is the first principle that should be kept in mind. In short, no recovery shall be ever effected by the government from its employees who are working on the group C or group D. This is first principle. Second principle, regardless of the group, it is A, B or C, D, no recovery shall be effected after the government servant stands retired, or no recovery shall be effected against a government servant who is nearing his retirement or who is likely to retire within a year from the date of the recovery, that is proposed recovery. Now, these are two broad principles. Third principle is that when the recovery is in respect of money that was paid 5 years ago, that is after the overpayment was made, span of 5 years has gone, and then government has started such recovery after the span of 5 years. In such case also recovery is held to be illegal as per this judgment of Supreme Court. Now these are three broad principles where recovery is illegal, and therefore even if the overpayment was actually made to the government servant, but government will not be in a position to recover that amount, and if the government actually starts initiating, starts recovering such amount, overpayment amount from the government employees, and the cases fall into these three categories, such recovery action can be successfully challenged or questioned in the court of law, either by approaching the respective tribunal like MAT or CAT or the High Court concerned. So this is the very clear position. Now the fourth principle, which is also very important, in that very case, Supreme Court says that in other cases also, the recovery may not be legally permissible if the recovery itself is unjustifiable. Now, in what circumstances recovery can be held to be unjustifiable will depend upon the facts and circumstances of the case. Now, in many cases, what happens? There is no actually role attributable to the government servant in getting that overpayment. He has not made any misrepresentation. He has not made any fraud in getting that overpayment. And after a long time, the government servant is subjected to such recovery. Then in that case, it may be held that recovery proceeding is not justifiable. So broadly speaking, these are the four principles in which the recovery of overpayment is not permissible. Now, in other cases also, like cases where the recovery may be permissible, still there are some legal requirements to be complied with by the government. For example, if the recovery does not fall into any of these four cases, but still recovery starts, then the principles of natural justice also come into picture, which require the government to issue a show cause notice, giving an opportunity to the government servant to explain the cause, to show the cause as to why recovery should not be actually effected. Now, this is not merely a formality or empty formality, because government often argues in the court that in fact the payment was made and that is not under dispute, and therefore the requirement of show cause notice is actually empty formality. But this kind of argument is not sustainable, because the principles of natural justice actually stand on the principle that justice not only should be done, it must appear to be done. So the show cause notice is a requirement stemming from the principle of natural justice, and these principles of natural justice are held to be part of Article 14. Therefore, even in other cases where the recovery may be legally permissible, but still the requirement of issuing a show cause notice cannot be dispensed with by the government or the employer concerned. So, in such cases where the recovery has been effected without following the principle of natural justice, that is, without giving show cause notice, still the government servants can successfully question and challenge in the court of law, like tribunal or the court. And in other cases where the recovery itself is not permissible, but still government, in many cases, despite the judgment of Supreme Court, actually starts, and employees are actually compelled to approach the court and get the stay order or the recovery action to be illegal. In many cases, it happens that government servants may not be in a position to know that it is their right to challenge, or it is their right to be protected, and they keep quiet, and government successfully recovers the amount, and the government servant loses the protection. So the government servant must realize that they are entitled to such protection after the judgment of Supreme Court. So to recap these principles: no recovery from a retired person, no recovery from a person who is likely to retire within a year, no recovery against a servant who is class C or class D group, no recovery in cases where the recovery is in respect of amount that was paid 5 years ago, and no recovery where recovery itself is unjustifiable due to the various circumstances and the factual position. So these are the broad principles. Now, where these recoveries can be questioned or challenged, the recovery action can only be challenged in the tribunal in case the government servant happens to be a government servant. Like government servant of Maharashtra government can question it in the MAT. A central government servant can question in the CAT, CAT. And in other cases where the it may be a corporation like public undertaking, etc., and other bodies of the central government or corporations which are not brought under the purview of the CAT, such employees can successfully challenge that recovery in the respective high court. So, dear friends, in this short video, I wanted to share this very important aspect pertaining to the government servants and their liability. And uh, this this kind of problem occurs in day-to-day service, and we come across many such cases where the government servants are subjected to recovery proceedings. And in many cases, it happens that they don't come to court also, fearing that uh, overpayment itself might be construed as a misconduct, that despite not being entitled to get overpayment, he has received the overpayment, and that may be treated as a misconduct on his part, and he may be subjected to another inquiry proceeding. So the government servant actually accuse, that is, they give a consent to be subjected to recovery. So keeping in view this Supreme Court judgment, the government servant should know their right, and Thank you, dear friends. With this video, I'll stop here. If you like this, don't forget to share and also comment, give suggestions so that we will consider the suggestions, and of course your comments will inspire us to make such videos. Thank you for the day.